Good evening, all. Yeah. Some announcements. This panel will not go beyond 30 minutes. Um, I know you are already bored to death. We don't want to do more of it. Just to give a prelude to this session, they are wonderful speakers, and I don't want to take time away from their time slot. I just want to make one point and hand it over to the panelists. If you look at, I'm just taking an example so that we have a comparison. If you look at the development of cellular standards, right? 2G to 3G and 3G to 4G and 4G to 5G. The time has been decreasing, but it is still at least 7, 8, 9, 10 years. Okay? So from the transition from 4G to 5G took around 10 years. So the legal fraternity had time to respond to these changes. Can you imagine or can you guess what is the rate of change of developments in AI? Just two. Is it 1 year, 2 years, 6 months, 2 months, 1 week, 3 days? One month? Okay. You are very optimistic. A week. Probably. That's very much it, right? So as legal professionals, where do you have the time to respond to these changes? Right? This is also an issue, a challenge, and at the same time it offers a very bright opportunity, right? Since the technology, especially AI and AI related technologies are changing at such a breakneck speed, as lawyers, we don't have to wait for the technology to change, right? You can think ahead and say, okay, here is the framework, and within this framework, the innovation should happen in these areas. Because the impact of AI, as you are already seeing, right? The impact of AI and the solutions and tools built using AI or based on AI is tremendous, right? If you don't have a framework in place for the innovation to happen, especially in these areas, it is very easy for these technologies to get out of hand and become uncontrollable, right? We don't want to be in that situation. So lawyers, especially IP lawyers and legal fraternity, has a fantastic opportunity to get ahead of technology, probably for the first time in the history, I guess. We were always followers and seeing how the technology moves, and then we used to respond. But here is an opportunity for lawyers to get ahead of technology, build ethical and governance frameworks for AI and related technologies. So it's a golden time for lawyers. With that, I would invite Kumar to talk about innovation and AI ethics. And if you look at the panel, Kumar would mainly focus on technology, innovation, and some legal issues related to technology-led innovation. And Swapnil would focus more on governance, code practices, what has gone well, what is not going well, and what could be done better, right? So with that as background, I'll hand it over to Kumar.
Can you hear me? Okay. So I think SK has said it all. I think we might as well just wrap up and go for the cocktails. But yeah, since they're not ready yet, we'll try to entertain you. So I'm actually not a lawyer, and I'm a technologist by profession. But throughout my career, I've been closely involved in sort of the intersection between technology and law. And so I've become very interested in that overlap. And AI, has created a new Wild West kind of situation when it comes to the intersection of technology and law. And it's almost everything that you knew is up for grabs all over again. And the clear guidelines and guardrails are yet to be established in this very rapidly evolving space. So I'll just touch on some of the key, some sort of points that we can use as a starting point for discussion. This is hardly comprehensive, but it's just a starting point, I would say. Am I supposed to point somewhere? Oh, okay, got it. Yeah, sorry. So I just want to start with 3 quotes that I read in just the last few days that really encapsulate where we are in this field. So the first one, I'll just read the highlighted one. It came in Nature because there was a paper that came out 2 days ago that basically said that, AGI is already here, right? So AGI is artificial general intelligence. It's already here. And they made a strong case as to why that is the case. And so what is interesting about this is that, one, this is, according to them, and it's an arguable point, it is the most significant scientific and technological revolution in human history, right? One can be skeptical about it, but if you really think about it, it may well end up becoming that. Because it's really about thinking, it's about intelligence, it's about analyzing, it's about organizing the world. And the second point they made is that this is happening at such an accelerated pace that the timeline is compressed beyond any historical precedent and could be accelerating. Just to give you an idea about acceleration, in just the last 2 days, Google announced that they're going to invest $185 billion of capex, and Amazon today said it was going to be $200 billion, okay? So, it's hard to get your head around these numbers. They're so huge, and that's why it's accelerating. The second point I want to make is that, this came out of a very technical paper and from the ACM transactions on intelligent systems, that the real discontinuity is not in the models. It's in us, in the speed at which our governance, our ethics, and our institutions can adapt to the pace of machine evolution. So if there's one takeaway I would argue is the most important today, it is that point. And the third, which sort of is the other bookend to this, is that the promise of personal AI assistance rests on a dangerous assumption that we can trust systems we haven't made trustworthy. We can't do that. So this is sort of the framing of where things are today. Now, just coming to ethical AI, I just wanted to put up a sort of a framework to think about it. Basically, ethical AI encompasses many different facets of this technology. And a lot of these are not, how to create responsible AI, in my view, is too important a job to be left to the technologists. Okay, this is the key point I want to leave with this audience. The technologists are like a runaway train going at, and it may end up becoming a train wreck for all of us. And it's really important for those in the legal community as well as in the social sciences to start moving forward quickly to understand and put some guardrails around it and get a seat at this table. Right now, if you don't move fast enough, you're not at the table. So there are a few things that I think are very critical. One of those is safety. I mean, is this technology that we're all beginning to use safe? Meaning, can we rely on it? Is it honest? Is it trustworthy? And at the end of the day, if something goes wrong, who's accountable for this? So accountability is an open question in this field today. And I think this is one of the major, it's an elephant in the room that I think the legal community really needs to get its arms around. The second is transparency. Half the time we don't know what's going on. Not even half, 90% of the time we don't know what's going on behind these AI systems. We don't know how they arrived at these recommendations? What was the logic used? What was the data sets used? No one knows. And at the end of the day, how much of this is simply reproducing unfair biases that we as a society know that exist and have historically tried to counteract through legislation and legal frameworks. Those don't exist. Those guardrails don't exist in these kinds of recommendations. And the third is data governance, which is, at the end of the day, the raw material for AI is data. And there's so many questions around that data, which is whose data, who has access to that data, what are they doing with that data, and so on and so forth. And so these, in my view, these questions need to be asked and really taken on as like a critical, mission critical task by the legal community in every major country, because the answers may not necessarily be the same. But that doesn't mean you don't leverage prior work being done elsewhere, but I think this is something that's going to be very, very critical, especially in a country like India where there's like tremendous amounts of data. So with that, I'll hand it over.
You were talking about data protection, right? And most of the discussions focus on who owns the data, how do we protect all these things. But especially in countries like India, getting a valid consent is very, very important. Suppose there is a micro banking system in hinterland of India, rural parts of India. Is the consent given valid, right? Would the person giving the consent know about what they are consenting to is something that needs to be critically evaluated, right? So there are so many languages here, and how would these AI systems get valid consent when you are getting personal data from them is extremely important, especially in countries like India. So with that, my first question to you, I'll come back to you and have a few more discussion points. What has been your experience, especially in the litigation arena? What is the nature or what are the contours of litigation that are happening, especially in India? And if you want to compare it with other jurisdictions, you are free to do so.
Hi, everyone. Thank you for the question. It's a very interesting question. And since the morning, we have been talking and discussing about AI-generated content, IP as a content. But what we forget about is that with creation, one comes the value, but second comes the vulnerability, right? And as far as the current legal mechanism is concerned, there is nothing beyond IP which can protect creation, including AI generated. Now the problem here arises is that as far as Indian mechanism is concerned, have we actually defined AI? No, right? That is the issue. Now courts, if you see, they are doing their work generally, right? So there are two aspects when we talk about courts in general. One is, as we all know, internet has no boundaries, right? It's dynamic in nature. Now, considering this issue, how do courts deal with it? Fortunately, now courts have settled this position. You all might be aware about a recent case of OpenAI, which is currently pending. And the issue there arose was that the defense of OpenAI per se was, sorry, our servers are not based in India. We are not here in India. What do we do about it? Sorry, who are you to tell me what I'm supposed to do? But then the court said, sorry, you're providing your services in India, right? So how can you get away with that? Fortunately, regarding as far as jurisdiction is concerned, Indian courts have been hyperactive and have been protecting it that way, and now the position is settled till now. Second issue arises is, we have all seen, IP developing and growing. And with each IP developing and growing, there has been a new issue altogether in the courts. With copyright, we had an issue before the court. With trademark, we had an issue before the court. Now, of course, AI, we have an issue before the court. So there are two ways the courts are dealing with it. One is that as far as e-commerce platforms are concerned, which of course now an issue. Everybody is, buying their stuff through e-commerce. Nobody takes that much pain to go to the physical store and buy the stuff. So as far as e-commerce platform are concerned, the courts are very clear that, okay, if there is something infringing in nature, you take it down. Now question arises, what is infringing in nature, right? So you have to prove it. You just cannot state it that, okay, this is something infringing. But fortunately, the law in India flows in a way that we have two remedies to that effect. We have interim and we have permanent. So as far as interim relief is concerned, courts are very much active in providing as far as that is concerned. Second issue is regarding intermediaries. They are a trouble. They are a trouble, really. Every platform you use, there is an intermediary. And all of them take a defense. In fact, I believe in one of the sessions, they were discussing that, intermediary, they take a defense of safe harbor, right? That we are just an intermediary. We are just, mediating this transaction, and I have nothing to do with it. And the court said, sorry, you cannot take the safe harbor, the principle of safe harbor, the defense of the safe harbor. But the problem here arises is that our legal system is designed in a way that it does not stop to one mechanism, right? We have single bench, we have division bench, and we have Supreme Court, right? So for example, if division bench gives a judgment, some way or the other it is either overruled or stayed by Supreme Court. In a very recent case of Wikipedia versus ANI, quite popular. So ANI sued Wikipedia regarding their defamatory content was being circulated on ANI. And the court held that you take this down, and as an intermediary, your duty is only to comply, only to take down. And you are no one to challenge the content, that whether it is infringing or not infringing. Unfortunately, the matter went to Supreme Court, and the Supreme Court stayed the issue. So even if the courts are active in one way, their hands are tied another way. So that is an issue. Now, third thing which the courts are dealing with is dynamic injunction, which is an interesting concept. There are other courts also in the world who are dealing with it, but India, as far as, is doing very well. So dynamic injunction is a concept whereby it's a content which keep on taking down as and when you report to the concerned intermediary or e-commerce platform. It's a very active remedy as far as Indian jurisdiction is concerned. But the problem is this remedy is ongoing. So if I am before the court questioning this and looking for this remedy, this is like eternal process. For how long will you be reporting this? And for how long it will be kept being taken down. So there is no permanent solution to this effect. Nothing. It's like you keep reporting, they'll keep taking down. So court per se currently are hesitant into getting into that technical aspect of it. That how is it possible that we can permanently deal with this? There is just temporary solutions going in the air. But nobody is talking about the permanent solution. Even the courts are quite hesitant. Currently, we have, of course, OpenAI case, which is the only case talking about generative AI. And we all know generative AI is an issue now. It has been recognized. Other countries have been dealing with it. But as far as India is concerned, that issue again is pending. So as far as we decide, we define what AI is, what generative AI is, it's very difficult to deal with it. The courts are doing their job in one way or the other, but I believe personally, it's my personal view that somewhere or the other they are lacking. In the morning, I believe somebody was mentioning about the India Mart case, right? Whereby the court did say that you are actively participating in mediating the transaction. But I don't know how many of you are aware about it, but unfortunately that decision itself has been said by a division bench, right? So that is the issue. On one hand, this is actively, courts are active, but on the other hand, there are, it's the same mechanism going on. So it's like contrary thing going on in the same jurisprudence. So that is an issue, and I think, it's high time that courts should be more hyperactive regarding this. So this is what I believe. So.
Thank you, Swapnil. We will start looking at innovation in this title, right? this is your favorite topic too. Uh, when we look at R&D investments in India, there is always the government investment and also the private investment. And what is unique about the R&D investment structure in India as compared to at least some of the developed countries? First question. And the second thing is, Government of India has floated several funding opportunities. For example, ANRF, the recent RDI, right? Research Development and Innovation Fund, which is 1 trillion Indian rupees. How do you, this is in a very, very nascent stage, right? How do you think these funding programs will change, especially the deep tech ecosystem in India? I'm specifically pointing out deep tech because I was just looking at some data, and in the US between 2016 and 2025, if you look at the number of established deep techs, right, it is valued at an estimated market value of 450 billion USD. And in Europe, there are around 600 deep tech startups valued at 250, and in China, around 500 deep tech startups valued at 400 billion USD. And in India, during the same period, we have seen 3,600 deep tech startups, right? Which is like 5 times as compared to the US. But look at the value. The value of these 3,600 deep tech startups is valued at 70 billion USD, right? And one major contradiction to this, or one major observation, of course there are several, or at least few. One important observation in this data is, as and when these developed countries started increasing the number of deep tech startups, their value went up, the estimated market value, and also their IP portfolio started growing. But in India, though the number of deep tech startups have increased exponentially, their value and the IP generated by them has remained almost flat, right? So from that perspective, R&D investments, especially schemes like RDI, do you have any comments on that?
This is, one can hold a whole day conference on these questions that SK has asked, but nonetheless, they're like really important. So I'll try to address them somewhat briefly. Just so that, because a lot of people are not aware of the answers to these questions in India. So the first point I want to make is, overall, India just doesn't spend enough on R&D. Okay. India spends, to be precise, 0.6% of GDP on R&D, which is tiny. Okay, put it in perspective, Israel spends 4-point-something%. US spends 3-point-something%. China spends about 2.5 to 3%, which are huge numbers considering the size of their GDPs. Remember, these are normalized numbers. Okay, we're talking about percentage of GDP. So even on a normalized basis, India is a huge laggard in this area. Now, that has had serious implications for India's technology independence. It is precisely as a result of this that India is not technologically independent at all. It is hugely dependent and hugely vulnerable on foreign technologies in almost anything that matters. Okay? Now, what does that mean? I mean, I hear politicians saying that we are like some kind of tech superpower and all that nonsense. In fact, we are nothing like it, because India doesn't own the intellectual property for any of this. It's all owned by companies abroad who have invested in R&D, okay, and governments that have invested in R&D, and that's why they have that edge. So that's one problem. The second problem is that the private sector in India simply does not invest in R&D. I would consider that to be a huge problem in itself. Because if you want to increase that level from 0.6 to something bigger, you can't put it all on the government and say, no, you just do it. In fact, in most technologically advanced countries, the majority of the R&D investment comes from the private sector, not from the government. That doesn't mean the government doesn't have an important role to play. Of course it does. And it has done so in the past. But the private sector has really stepped in and done a lot of that. And so if you look at, many of the most important inventions that came out, that created entire new industries, they came out of the private sector. I mean, a transistor is a classic example of this that came out of Bell Labs. So uh, the Indian private sector does not invest in R&D because R&D is a risky thing. You know, it's an expense and it's risk. It's hard to get ROI on that and convince your shareholders that it's money well spent. And unless the private sector gets tax incentives or some kind of incentives to invest in R&D, they're not going to do it. The other reason they don't do it is because India is a very underpenetrated market. You don't have to do it to compete. You just need to acquire technology from somewhere else if you need to, or you do business model innovation, or you scale out, you know, and come up with economies of scale in India. And you know, they could be doing this for the next 25 years and still make good profits. But the result of this is that you're not competitive internationally. You don't sell products internationally because to be competitive internationally, you need to have a technological edge, and India does not do that. And there are many side effects of that. One of those has to do with the balance of payments, and you know, this is one of the issues that keeps coming up with China, with the United States and all that, where we end up importing a lot more stuff. We don't have enough dollars, and then we have to put currency controls and all that nonsense. And when something happens to the US dollar, then it affects us and all that stuff. And it's all because, you know, we're not exporting enough. So that's the second. The third is our higher education ecosystem is very backward. I'm sorry to say. You know, there's so much talk about, you know, we have IITs and we produce great engineers and so on. And I would say, you know, we do produce pretty good teaching institutions at an undergraduate level, at least at the top. But our research and innovation competency, our linkages to industry, etc., are extremely weak. And, you know, I think India has a very, very long way to go. It has to really improve the quality of its game in the higher education sector in this respect. The curriculum, the pedagogy, you know, you can't have a rigid education system that does not reward original thinking, controversial points of view. You know, you need to create an environment where students can challenge, you know, the prevailing dogma and not be penalized for it. So I think even culturally a lot needs to change in India because of this. So this technological dependence that India has found itself in is a dangerous situation because it, you know, you're basically handing leverage to other countries. You know what Trump has been doing to all countries. And most countries have woken up and said, you know, we can't let this happen anymore. China is a classic example of this. And India's also begun to do that, to its credit. And it's actually started many of these R&D. The government has been very proactive in its, I mean, in all fairness. I mean, I would not criticize the government of India at all because they have really responded quickly. They've started doing the right things. There's a learning curve they're going to have to go through. They've created the equivalent of what, you know, the US government had created. They created agencies like the National Science Foundation and DARPA and all that the US has created. They're replicating it here. Of course, it's going to take a while to get these to become effective functioning organizations. But there's a whole pyramid that needs to be created in India that does not exist. And, you know, and that's a huge, huge challenge for India going forward. Sorry, that was a bit long, but.
Okay, yeah, thank you. That gives a very good overview of and insights also. What are your suggestions? You talked about challenges, the state of the art that is happening in courts today. But if you have two suggestions on changing something, what would that be?
Well, you know, I cannot agree more with Ranganathan's son. The problems he pointed out that, you know, we lack in R&D. That is true. And, you know, the solution lies in the problem majorly. What we are lacking is one, of course, R&D. And second, you know, in startups, we have now startups coming in. We can have better LED lights, but we will not invest in our IP. That is true. we hesitate in investing in our AI. We think if we invest, this is a huge investment coming in. And that is the reason we suffer later. And the other issue is with the tools. Sir is right that, in one form, the government of India has worked a lot, and we cannot blame them for it. But coming from this background, I have been dealing with cases, as far as criminal cases are concerned, in cyber. If you go to the police station, they will lack basic tools of, for example, sourcing, right? So everybody knows here that VPN is the tool every hacker is using. And if you want the police to trace the actual criminal through that, it's an impossible task for them, because they know they lack that kind of tools, and they admit this fact. And as far as courts are concerned, I believe, they are going more of, towards preventive protection rather than reactive enforcement. What we are looking for is enforcement, and they are stuck into, protecting the infringers, for that matter. So I think one suggestion, it's very basic suggestion, is that, homework start at home. Yeah, your learning start at home. So we should not hesitate in investing in our IP. We should start protecting our IP from the very initial stage. Many people have actually talked about it in the morning session as well. And second thing is, we should not, be hesitant in joining hands with other people. Like, as far as I believe IT is concerned, or cyber is concerned, or for example, innovation is concerned, lawyers should never be hesitant in joining hands with technologists. Because how will we know the technology? We, as lawyers, we are not well versed with technology unless and until we have a technical background, right? So we should not be hesitant. Third is, as far as economy and IP both are concerned, they go hand in hand. If you believe in economy to be growing, companies should not be hesitant in licensing their IP. I have seen companies being very hesitant about licensing their IP. We should not be. If that can help in, growing the economy per se, that is a good solution. And of course, in the end, I would just suggest, it's just a suggestion per se, I don't know how much will it go, that courts should also be, they are active, but this is the era, this is the time that if we need to keep pace up with the technology, the courts have to go hyperactive from being just active. So that is it. I will just conclude.
Okay. Thank you very much. You were talking about R&D investment and role of government and role of private sector, right? In India, the government investment into R&D is around 65%. Private, around 35%. But in most of the developed countries, the R&D investment, the portion of the R&D investment that comes from the government is around 30%, 30 to 35%. And rest of it comes from the private sector. So it's exactly the mirror image of what's happening in the developed countries. Definitely that needs to change, right? With that, they have done their job. If you have any questions, probably 2 or 3 questions max, we can take those questions and then close the session. Any questions? Yes, please. 1, 2. Do you have one more? Okay.
Check. Yeah. So my question is to the panel, right? So this risk that you guys were talking about with regard to AI, right? Do you feel that the risk would be mitigated if provisions of the European standard for data privacy, the GDPR, they were extended to India and those provisions were in fact applicable to India? Do you think that would mitigate the risk?
Okay. Good news, we already have DPDP, Digital Data Protection Law in this country. And recently, probably 4 months back or 5 months back, the rules also came out. So we are on that path, right? And if we look at the features of DPDP, it is mimicking, in many respects, it mimics GDPR. So from a law perspective and the rules perspective, I think we are in a good shape. How do we go and implement it effectively is something that needs to be seen, right? So any other thoughts? Okay.
Sir. Yep. Sir, I have a question. So recently Grok was in the news for its image generation output, where it had created some very unethical images where it has been being created. Some of them are of minors, and some of them are also copyrighted content. And it was banned in, I think, EU, Turkey, Malaysia, Thailand, many other countries. Does India have any mechanism in place to tackle with such kind of unethical and illegal image generation?
So, see, there are two ways. There is one mechanism which is the internal mechanism of that particular platform. And the other way is that you approach the court. Now, the benefit with Indian courts is that once you approach the court, they will issue an interim injunction to that effect and a direction whereby they will be directed to take down the images with immediate effect. And second remedy is through dynamic injunction. So once the person whose content is being uploaded or whose whatever images are being uploaded there, they can report directly to whatever agency or Grok is being handled by, and they will keep taking it down within 36 hours of reporting. So there is a law to that effect, that there is a timeline to each and everything. So for example, you're talking about minor or pornographic content to that effect. So the timeline to that is 24 hours. So this is the mechanism which is in place already, and this is actively going on.
But wouldn't it make more sense if the government tells X that you have to put restriction from even generating such content? Because if you say a pornographic content is there on the internet for 24 hours, the damage is already done.
Yes, I agree. And this is what should happen. But the problem arises is that they have admitted in courts of law that they do not have that kind of technology yet to actually implement this. And I agree with you that, the check should take place at the very initial stage. But unfortunately, that is lacking as of today.
I just want to add one point to this. I think that it's easier said than done because, India has rightly been called the Republic of Hurt Sentiments, right? Anybody can challenge anything that's put up there because it hurts some public sentiment. And at the end of the day, this sort of vague and broad-based support in the law it really stifles free speech. And so there is a trade-off. I mean, how do you safeguard free speech while simultaneously placing curbs on certain things? I mean, that's a challenge every country has, but India has it in spades because we actually support this notion of banning content that hurts sentiment. Whereas in a country like the US, the bar is, it's a standard for banning something that is expressed is way higher than this. So, you have to be very careful when you go right and left and ban this and ban that, because every time you're setting a precedent, what does that do to your jurisprudence, right? You can't be whacking a mole your way through this, right? You need to develop a principled jurisprudence on how to handle these things, and I don't think India is there yet on this.
Yeah, a little remark, but I maybe need 4 minutes for that. I have the pleasure to do a lot of work for DRDO and developments which take place at various places here. And I know that Indian companies, not only in DRDO, but also in, here's a famous Tata consultancy service. I do a lot of work for them, everything in Europe actually. And what I see is the following, and it is exactly what you are talking about. We need all, in order to make more capital available, which can be injected into R&D, you need more income, I think, as a country, as the government, to give this into certain projects. In order to do that, you need solid fences around a garden of innovation where you get beautiful flowers and valuable inventions and so. And India just refuses. Sorry, it is not blaming anybody, but in India you cannot patent and making a strong fence out of inventions which have to do with security relevant, I call them all military inventions now. You cannot do this. India has said no. For ethical reasons, I fully respect that is not patentable. But you should know that there is, and you will certainly know, everybody knows this, there is a flourishing international market for such type of inventions because certain countries, People's Republic, PRC, China, Russia, Germany, Japan, they all have secret invention systems. That means when I file certain applications, maybe for a German subsidiary of a Chinese company or for a German company, ThyssenKrupp is a wonderful example for all these things, or Rheinmetall. When you file an invention for a patent in Germany, I'm not entitled to do this at the European Patent Office. I must do this at the national, so far about unity and Europe. So you must do that as your Britain, the same thing. At your patent office, they put, if they think it is really security relevant, a secrecy stamp on this. From then on, and this done, by the way, by an entry group of 3 special examiners at the German Patent and Trademark Office, who are not employees of the German Patent and Trademark Office, but Ministry of Defense. They are delegated to sit there, and each and every invention is screened there. Now, after that stamp has come, the invention is not out of the hand of the applicant. It is only treated in an absolutely secret procedure, and certain patent attorneys, I don't advertise for myself, but I'm one of them, there are more in Europe, they can handle this. And if you wish to go, I was often in USPTO for certain things like this, then I have to go in Germany, Ministry of Defense, Foreign Ministry, US Foreign Ministry, I call it now like that, Ministry of Defense, and then you get entry into a certain division there. And you see all of a sudden that in these countries, US, who have highly valuable security relevant, not only military by which you can shoot. Nowadays we are talking about cyber war or so it was. They have, or something like this. There was a German introduction in my speech. They have these patents, then all of a sudden, India, by not participating in the patenting process for such type of inventions, in spite of wonderful inventions, particularly in the software area, the AI area, made here in India, does not have fence there, so people don't invest there, because only if you have a protected area where companies and private companies can invest and are protected by patents, then you have a currency for freedom to operate cross-licensing procedures, etc. in your hands. India does not participate there. That market, you see the straightest elements, because even licensing negotiations are under control, of course, of finally the Ministry of Defense, security agencies, whatsoever. US does this, as I said. China does this, not necessarily with the same clients or customers. Britain does this, Germany does this, Japan does this, all wonderful. So why not replacing the well understood for ethical reasons prohibition of patenting defense relative inventions, giving it up, and you make it patentable. You will all of a sudden be in a new world of huge income. Imagine what amounts of money India pays, for example, to our beloved United States for military technology, which is bought and paid in cash. As soon as you can pay this, at least partially, by cross-licensing, then there is a balanced trade in with these inventions. This is in very many technologies. So when you come to Cisco and say, I wish to have a patent under this and this chip, I know this myself, system or whatsoever, they will say, in which currency do you wish to pay? And you say, US dollars, Japanese yen, rupiah, whatsoever. And they will say, no, I accept only one currency, cross-licenses under your patents. And then the General Counsel looks back and says, where are our patents? I wish to cross-license them. And they had this in Shenzhen in the early days of this millennium. And there was nothing. There was one pending US application, and then they have started with huge cost a program to create patents, not for attacking anybody, but to have a special currency available by which you pay instead of cash or replacing at least one part of cash, this allowance to do certain things here. I think that would be very beneficial for the public sector, for the government of India, if one would make this change in law. There was only a little proposal I wanted to make because I'm talking about this with DRDO all the time. Thank you so much.
Yeah, 30 seconds to respond to you. The Patent Office and the Department of Commerce and the Government of India, they are taking steps in the right direction. Just to give you an example, atomic energy related inventions were not patentable at all. But now there is a carve out and we are on the path. We will be there very soon.
I spoke 2 days before with
Yeah.
DEI and the directors.
Nuclear energy related inventions are now patentable, certain classes. So,
Yeah, I just want to make one comment on that, on this topic. See, India has begun to realize it must build out its own military industrial complex. It doesn't have one, really. That's why India is, it acquires all its arms technology from abroad, whether it's Rafale jets, whether it's Bofors guns, whatever it may be. Now, the creation of a military industrial complex for a country as big as India, fourth largest GDP in the world, is absolutely an imperative. There are other side effects of doing so. You will create a deep tech ecosystem by investing in the creation of a military industrial complex. And to do that, you will have to actually create your own IP and patent it and go down exactly the path discussed here.
thank you so much. Thank you all.
Thank you so much, Dr. Murthy and distinguished panelists, Mr. Kumar Ranganathan, Mr. Apnil Gaur. This session very powerfully underscores that ethical governments must evolve alongside innovation, and that ensures technology serves human, not the other way around. Thank you once again. This is our concluding session, so may I request Rajat to come and present these mementos to the panelists. Thank you. Thank you so much. Thank you. Yeah, please.